right, next case will be SAIBABA of Orlando, I may have mispronounced that, versus SITEK Corporation.
You probably mispronounced that too.
I mispronounced corporation. Appellant's counsel may proceed.
May it please the court, Your Honor, my name is Eric Shutoff, and I am counsel from Lawyers Today for the appellant, and it is SAIBABA of Orlando, Incorporated. I would like to reserve 5 minutes of my time for rebuttal.
All right, you may proceed.
And acknowledge that the president of SAIBABA is in the courtroom today. SAIBABA has come here and filed this appeal because two very significant issues in the construction industry are at stake, Your Honor. These issues were addressed by the trial court incorrectly. The trial court committed reversible error, not in finding in favor of SITEK Company on its breach of contract claim. We don't dispute the underlying decision by the trial court on that respect. But the court committed reversible error when it found in favor of SITEK on a lien theory. The lien theory was improper and cannot survive for two reasons. First, there was a clear, unequivocal, unambiguous waiver that was executed by the president of SITEK Corporation and provided to my client in exchange for $45,200 on July 19, 2012.
Just one waiver or two?
It was one waiver that was executed and notarized and provided to my client.
Was there an initial waiver where there was a clean waiver and then the second one reserved?
There were, what the court may be speaking of is, there was an initial draft prepared of a waiver. The waiver that was executed and provided to my client was clear and unambiguous, releasing all lien rights through the date certain of July 19th. That was provided in exchange for the consideration of the $45,200.
I understand your argument about unambiguous, in that it said that there was retention plus any work that would be done after that date. So we'd have to know what retention is, correct?
That's correct, Your Honor.
All right, so until we know that, we don't know if there's been a waiver, express waiver or not.
It is clear and unambiguous for this reason, and I agree, we need to visit the issue of retention, but the language comes directly from Florida statutes. That waiver language is mirrored, it is pulled directly from the Florida lien statute. It was copied verbatim by the SITEK Corporation, which prepared the release. We don't think it's ambiguous, but if there was any ambiguity, the law is clear that it should have been construed against the drafter. They were always at liberty to say there is still a balance due and owing which we consider to be retention or which we consider to need to be held back. You do need to know what retention is.
Disputing that indeed there was a balance due and owing.
Right.
And so in order to do a favor for your client so that the bank will release the money, he executes a release. Correct?
We don't dispute that there was money due and owing because the court made that determination.
Clients makes comments, oh, we'll make it up to you, we'll do this, we'll do that, but the bank won't release the money unless you give us a release.
Yes, Your Honor.
So it gives them a release and includes in the release that it doesn't cover and the word retention is used. Why isn't it a legitimate construction of that lien that the retention reflected the monies that your clients admittedly owed? Because, in a word, retention is not the same thing as a balance due. It's not the same thing any more than a security deposit is the same as rent. Both are monies paid to a landlord, and
the layman would say they're similar things, but they're with distinctly different purposes. Retention is used in the statute, and it is used within the industry to define something that is specific. It is agreed to by the parties at the beginning of the contract stage, when they first sit down.
Retention equals retainage, but there is no difference, right?
Retention and retainage, those terms are both used interchangeably in my experience.
Retainage is one type of retention, and another type of retention is what you had here, was that the money was owed, but there was an agreement that it would be paid later.
The term retainage appears in the statute, and the term retainage in all of the materials that we have supplied to Your Honor is used within the construction industry to mean money that is specifically allocated as a security to ensure the work is satisfactorily performed through its completion. It's held back by the owner as a security to ensure. Typically in the retainage situations, and I first learned working for Anchor Construction, retainage is always addressed in the draws that are made to the bank. The bank is able to see clearly a percentage that is being withheld from each pay application made. There was no retention named in the original agreement. It was a one-page document executed between both sophisticated businesses which had made multiple million-dollar projects together.
Let me ask you this. In interpreting that word retention, could the trial judge take into account that, I believe it was earlier the same day, there was a release done for the full amount, and it said full release, didn't have that language, for $55,000 some odd dollars. Then your client indicated, we can't pay you the 55, so they sent it back, and then here comes the 45, saying that it's a progress waiver, and says forth that there's a retention, that doesn't include retention. Can the trial judge consider the fact that both parties agreed earlier that $55,000 some odd dollars was due, and that was going to be a full release, but because it wasn't there, there was a progress release, and the figure of $45,000 was put in, and then also the term retention. Can the trial judge properly consider what had happened earlier in the day between the two parties in interpreting what they meant by that term?
It did not, because, first of all...
Could the trial judge consider that?
We would say no, Your Honor, definitively no, because the release itself is clear and unambiguous.
It may be clear and unambiguous to you, but at least two of the three of us sitting up here don't necessarily hold that same view. And so I'd like to have you answer that question. Could the trial judge make that, look at the circumstances, look at what had occurred earlier in determining what the parties meant by retainage in this release?
If the trial judge did that, the trial judge should start from the standpoint that if there's any ambiguity about what this means, it's to be construed against the drafter.
Let's see, we start out with the monies to be paid, and we'll give you a release. And your clients say, we don't have the money to pay you. We're 10 grand plus short, and we can't pay it. So they send a second one that has this retainage language. Why isn't it logical to put those two facts together in terms of determining the intent of the parties?
Well, the first thing, by its very nature, that interchange that you're describing makes very clear that the parties are not using the word retainage or retention ever as it's used in the statute or within the construction industry. They're talking about a balance that can't be satisfied, an amount that's due still on the account, and we agree with that. The trial court ruled that way in giving breach of contract remedy, but not lien rights here.
But the first one, the first lien that was released, that was sent, said waiver release of lien upon final payment. That is, all the work's been done, and you're going to pay us $55,853. Then the next one says waiver release of lien upon progress payment. So the parties are going to refer to it as a progress payment, even though they know the work's already done. So retention would seem to relate only to the amount that's not paid yet. Otherwise, it doesn't make sense in consideration of the whole all the circumstances.
The two releases have the exact same effect, Your Honor, and here's why. Because they are for services through a date certain. They are through a date certain. The issue of progress payment versus final would be an issue if any work was performed after July 19th, when the waiver was executed. There was no work performed after July 19th, and in fact, SITEK, when it issued its claim of lien, said that the work had ended on July 17th, so there's no work being performed afterwards. That's the difference between a progress waiver and a final waiver, is whether work is final and has been performed or not. There's no dispute in this case that the work ended on July 17th. So there is no additional work. The only issue is this money, and this money is not retainage as it's defined in the statute.
Parties agree that to consider it retainage?
Did the parties consider? Well, they do that at the initial stage of the contracting.
Things have changed. They thought, silly them, that they were going to get paid for the work that they did, and that your clients would meet the obligations that they entered into when they negotiated a contract price. And your clients presumably thought that they'd be able to pay him, and then circumstances changed.
If the
Parties recognize the change in circumstances and address it with this language?
If that view is adopted, it could turn the entire construction industry on its head. It will. Here's why. A simple email with some receipts attached to them sent from one party to another says, hey, you owe me for some paint, you owe me for some extra incidentals, and you say it and you put that on to create a track record that some money is owed. Then you go and execute a lien that comes from the statute, a waiver of lien that comes directly from the statutes, Your Honor, and then you can come back around and say, oh, the money you owe me for the paint and the materials here and there, I told you about that, we talked.
This case is different because your client sent an email saying, yes, we owe the money. So
And
it's not going to turn the construction law upside down. In your case, your client sent an email, said, yes, we owe the money, so we can't. So, I don't see what retention could mean in the second release, other than the $10,000 that your client admitted was owed, but didn't have available at the time. And also go back to Judge Cohen's point, the reason they did it was so your client could get money from the bank.
Well, to begin with, they prepared this release. They could have specified and made very clear that the $10,000 owing was retainage, or that the waiver of lien claims. And again, we're talking about the difference between lien and rights under a breach of contract, which are very significant and different things. Lien law gives them the ability to tie up title and financing. Lien law can even let you take a homeowner's house, notwithstanding the great protection of homestead exemption. Why? Because
we don't have, this is a convenience store, so we don't have homestead here,
But lien law is very strictly interpreted, and it is because liens involve such great powers, Your Honor, above and beyond what one can claim under breach of contract, right down to attorney fees.
The waiver of lien was prepared at your client's urging.
It was prepared after an interchange. It was prepared by the SITEK Corporation and notarized by their own notary.
But it was your client's urging. But for your client's urging, we wouldn't be here.
It is, again, a lien waiver it is a waiver about lien rights, which is so critical. That is why we are here. It's not about the $10,000. That was decided by the trial court below. But the trial court was in error when they said that there were lien rights notwithstanding this release. Now, there's a second factor that we haven't talked about yet, and that's the contractor's affidavit that was never prepared by SITEK Corporation.
Let me ask you about the second issue. It seems to me the case is pretty close to our prior decision in Rivera.
Yes.
Agree with that?
I would agree. I won't even try to distinguish it.
You have a complaint that says all conditions preceding have been performed, and then you have an answer that has a general denial but doesn't with specificity say that there was no contractor's affidavit provided.
Correct.
All right. So I'm trying to, what I want as a starting point, are you saying that this case is distinguishable from Rivera, or that Rivera was decided incorrectly?
I respectfully submit to the panel that Rivera was decided incorrectly, and that other decisions by this panel, including Sowers versus Henstein, are the correct view. And the reason that the Rivera decision is incorrect, Your Honor, is because it makes no mention of the Florida Supreme Court's directive in 1953, Sheffield Briggs, that lien law has to be strictly construed, the requirements. But more importantly, it neglects what Florida statute reads. And Florida statute says a contractor shall have no lien rights until the affidavit is served and on the contract, on the owner. The contractor shall have no lien rights. Where the mistake is, it's not about conditions precedent ultimately. It's not about pleading an affirmative defense with particularity. It's that no lien rights exist to begin with. The statute could not be more clear in saying that a contractor shall have no lien rights until they file and serve that affidavit. And there's a reason for that. That affidavit is my client's only protection to ensure he's not going to have to pay twice for services rendered by some contractors working for SITEK. The affidavit...
If your clients had paid once.
What's that?
He would have been happy if your clients had paid once.
But he would not have had the protection against someone seeking a subcontractor for monies that they were not paid by SITEK. There's a reason that we have that strict requirement that appears. It's not about a condition precedent. It's about there is no lien right until it's served.
That we would have to go in bank to receive from that case. Is that what you're suggesting?
Your Honor, I am suggesting that whatever it takes to make the record right, to clarify the law, lien law in Florida should be taken. There are numerous cases that we have cited from the 5th DCA, but the 4th DCA and several others, Leader Mortgage, Bishop Signs versus McGee.
A particular issue about a contractor's affidavit, are there any other DCAs in this state that have gone with your argument?
I'm not aware of them directly looking at the underlying statute as they should have.
Are there any other DCAs that have agreed with, or come to the same conclusion on this exact issue as Rivera?
They have agreed that the issue of the contractor's affidavit can be raised, just like it was with us, right up through trial in a motion for directed verdict. There are at least 2 cases cited within our brief where DCAs have said it is perfectly legitimate to bring that issue in a motion for directed verdict, and one of them is the 5th DCA.
The issue of whether the defendant has to raise with particularity the lack of a contractor's affidavit, it appears there's at least 3 DCAs in the state that have gone against you. I'm asking if there's any that have gone for you on this specific issue.
Yes, the cases that have gone, this court in Sowers versus Henstein, Bishop Signs...
That's a broader language. I'm talking about the idea that a contractor's affidavit is not raised as an issue by the defense in their answer. And when they try to bring it up at trial in a motion for directed verdict, and the trial judge says waived, or doesn't say waived, would you agree there's at least 3 DCAs that have addressed that issue and said if you didn't raise it with specificity in your answer, you can't raise it at trial?
When they view it as a condition precedent and they view it in the microscope of civil procedure, that is correct, Your Honor, but when they read the statute and when they read the Supreme Court decision...
We have 3 appellate courts that have addressed this issue, exact issue, correct? And they've all gone against you?
Yes, but they have not addressed the issue of the clear statutory directive.
That's wrong.
And that's what you're...
I'm saying, Your Honor, that those courts did not examine the underlying statute.
They're wrong.
Then they are, yes.
All right. You're well into your rebuttal time, but do you want to save the rest for rebuttal?
Yes.
Okay.
Joseph Ryan, Your Honor, appearing on behalf of Appellee SITEK Corporation. Judge, regarding the first point, the word in the statute incorporated into the lien is retention. It is not a defined term. The case law that I've cited suggests it be given its plain and ordinary meaning.
But aren't they right that typically in a construction contract, it's the initial contract will address retention issues?
Yes, Your Honor.
And this did not?
This did not, Your
There
Honor.
was no call for retention because it was supposed to be paid in full?
A lump sum payment. Yes, Your Honor. Now,
So isn't retention in the construction industry a word of art, rather than looking at it, under, the facts and circumstances of this case?
Judge, I would disagree. All the words, and we're splitting hairs here, obviously, but this is what it's about, they use the word retainage. All of their secondary authority, none of which was presented to the trial court, deals with the word retainage and how retainage is created. That is not the word used by the legislature. He is effectively arguing to rewrite that portion of the statute to say retention, only retention created by a contract. And was that the result or the intent of the legislature? That could have been put in there. But the word is retention. The legislature chose not to define it. Its ordinary meaning means that which is retained. And I think that the trial court made the appropriate decision in construing this.
Isn't part of the concept that it allows lenders, who are making, payments out on a construction contract based upon a schedule, it allows them to see precisely where they're at in terms of loan payments?
I would agree, that's one of the purposes on that, Your Honor. And in this case, when we gave the release, we specifically provided as release on a progress payment. We gave a photocopy of a final release in the morning. When they responded and said they didn't have enough money to pay it, we responded with a original release that was specifically on a progress payment. So this is not a situation that would have jeopardized the rights of any lender or not put anyone on notice of what happened.
Well, but a progress payment indicates we've done this percentage of the work and there's this percentage of the work left to be done. That's what a progress payment is.
It certainly indicates...
This wasn't a progress payment because the work had been done.
In this case, I think the word progress payment means that there is an amount that is still being retained and that any lender or any other third
That's kind
party...
of twisted logic, isn't it? I know that's what you'd like it to mean, but how logically can it mean that?
That an amount is being retained, I like Judge Advance's characterization of retainage as a subcategory of the word retention.
I was just throwing that out as a possibility.
I thought it was brilliant. But if we're sitting here and we're interpreting legislative intent, the legislature could have put retainage in there. They could have put retainage as created by a contract. It didn't. It just said the word retention.
You have, retainage after the fact. That's effectively what you've tried to do here, which is to call this retainage after all the work's been done because there's not enough money to pay it.
I disagree with that because we have, in simple terms, $55,000, they're paying us $45,000 and retaining the rest. I think that's the proper definition of the result of an act of retention.
But you call it retaining the rest. There are other words that can be used, and it seems that retainage has a meaning within the construction industry perhaps different than it would have in, the ordinary course of the use of the English language.
And Judge, the authority that he cited in his brief simply suggests that retainage usually is created by contract as a function between the party. It does not preclude the use of the word retention as that is which is retained by the owner. And respectfully, Judge, I think we're focusing in the brief on one purported principle of statutory construction and contract construction. But the Florida Supreme Court, in the case of cited, also emphasizes the court will endeavor to give a just and fair construction to a contract whenever possible that will lead to justice between the parties, and one that will not shock the conscience.
Construction contracts, particularly lien law, are very specifically, governed, and it's not, general contract interpretation that, in terms of fair and just results. You've got a very specific statutory scheme that you don't have elsewhere.
Okay. Well, and Judge, the alternative argument they've made is this is incorporated into a contract, and they've also argued it in terms of a contract construction, which is what generates my comments on that. But respectfully, Judge, I would say either way you interpret it, the appropriate result is that the amount was retained, that to expand the definition and essentially insert words into 713 that would limit retention to amounts being held pursuant to contract would be inappropriate.
Did the original contract allow for attorney's fees?
It did not, Your Honor. It did not.
Would it be incorrect for us to just construe that $10,000 your client agreed to the other side to be construed as, say, an extension of credit as opposed to a retention or retainage or whatever term?
Well, if that had been done at the start of the contract, but I still think the use of the appropriate dictionary definition to give its plain and ordinary meaning to a word would mean that which is retained or kept by the other party.
If it were a loan, it would be interest-free, apparently.
Well, 4.5%, Judge, we're trying to get. So on the final or the second issue that is raised on the brief, there is no contrary case law to Rivera. The facts of this case and Rivera are virtually indistinguishable. The other DCAs who have addressed it have adopted this, and I don't think there is any basis for the court to revisit its decision on Rivera.
You don't think simply the fact that Orfinger wrote it is enough?
I think it's a wonderful decision, Judge. I compliment Judge Kest and Judge Orfinger. If there are no further questions, thank you.
Let me mention, I appreciate your candor on Rivera being pretty much on all fours. And the reason for my questions is, I understand your argument. It's a reasonable argument that the statute says you don't have lien rights until you do your contractor's affidavit, and that the statute should take priority, if you would, over pleading requirements. And so I was just asking you whether there are any other DCAs that have gone your way. So in essence, though, to accept your argument, we'd have to go in bank, recede from Rivera, and certify conflict with the other DCAs. That would...
Currently, procedurally, that may be the case. I would only say that there are numerous appellate decisions, DCA decisions, that have adopted a viewpoint that the issue can be raised at any time, but thank you, Your Honor, it is. It is, just one clarification, the statute doesn't say just lien rights, it says there is no lien until it's served, and then no cause of action. So, yes, we would support that. I'd only also point out that the word retention was never tracked in their own testimony. If you go back to the trial transcript, you'll see that the president of SITEK said that they never put any monies recorded in the retention column for how they tracked it on the books, so they didn't even consider this money to be retention. That's evident from the trial testimony of the president of SITEK.
Both sides agreed what it was, though, right?
The amount of money that we were trying to do, yes, you described it as perhaps an extension of credit. That would be a more accurate description than retainage would ever be.
There would be nothing on the books because this came up at the very last draw. So how could there be anything on the books?
There were actually statements prepared after this very last draw, and the bookkeeping was kept, and there was a ledger kept, and at no time will you see this dollar figure listed as retainage.
Thank you. Your time is up. Thank you both.
Thank you.
We'll be recessed.